Unfortunately, in New Jersey, especially during more acrimonious or hostile divorces, a party may not always act in good faith. Sometimes accusing a spouse or partner of domestic violence is meant to induce that party to act a certain way that's advantageous to the other party, or force certain other issues in divorce cases. However, you should not feel manipulated, especially if you've been wrongly accused. Only documented predicate acts of domestic violence entitle a party to a temporary or a final protective order in the state of New Jersey. If you believe you've been wrongly accused, it's important to have copies of all of the messages between you and that party. If you have, especially if it's any messages where they describe any injuries that they might use pictures of to say that you did something to them when those injuries resulted from other things such as normal day-to-day actions or accidents. Also, it's important to have your own witnesses that have witnessed you acting in a normal and loving way with your spouse, especially because in restraining order trials, parties will often try to attack the alleged aggressor's character or show that there's been a history of domestic violence. If you know that that's not the case, make sure that you have all of your ducks in a row. You have all of that conversation evidence, all of your witnesses that can demonstrate your character in the event that the other party tries to attack your credibility or brings their own witnesses that say certain things happened a certain way, but your witnesses were there on the day and can definitely demonstrate that things were not as are being alleged. After you've been accused of committing domestic violence and your former partner has requested a temporary protective order, you will be served by someone from the court. You'll likely get a certified copy in the mail, or you might be even personally served. It's important to immediately thereafter contact an attorney to try to get you in the best shape possible before trial. You cannot miss your trial date, as sometimes judges enter default judgments against people that do not show up to court. You want to control the narrative. You don't want to essentially have a judge believe one version of the story because you did not show up to court or you showed up to court unprepared. Judges will often grant one short continuance for either party to obtain representation or an attorney. You should definitely contact an attorney and describe and be prepared to give a timeline of your relationship. Have that copy of that restraining order that's been served upon you for the attorney to know what you're being accused of and what's going on. If you have text messages where that other person is being inflammatory or harassing you, because oftentimes, especially if the relationship was toxic, you can also file your own restraining order against the person. If you're a father and you've been wrongfully accused either of an act of domestic violence or perhaps accused of not paying child support or not providing for your child or not having a presence in your child's life, there are several actions that you can take to ameliorate your legal situation. For example, you can and should go to an attorney with concrete evidence of your efforts to support or parent your child or your communications to try to get parenting time. You can also bring to your attorney's office photos of your apartment demonstrating you have a suitable apartment or house for your child, pictures of their bedroom, copies of any money spent towards supporting your child with school, such as clothing, school supplies. You should definitely document and bring to an attorney any proof that demonstrate that your spouse has been withholding or manipulative based on unreasonable demands. For example, if they've been withholding seeing the child because they want you to pay certain things that are unrelated to your child. All of those are necessary for a judge if an attorney brings an action on your behalf or is tasked with responding to one that your former partner is bringing in bad faith against you. So, rebuilding or reestablishing your credibility with the courts after an allegation is made against you is highly important because it can affect the judge's decision on other important matters such as child custody or parenting time. It's important for you to bring your own documentary evidence showing that the narrative that the other parent is trying to establish is simply false. You can show the court efforts and documentary evidence of your steps, your actions taken to help support your child or to maintain a presence in their life. You can show the pictures of the bedroom that you've created for your child in your new home. You can show any steps that you've taken to try to be closer to your child, such as moving to a neighborhood closer to their existing school or matriculation efforts to another school if your plan is essentially is to ensure that there's equal parenting time and the kid might have to move. You can show certain things like communication attempts with the other parent to try to establish a parenting schedule or a routine. You can show certain things such as positive communications with your child if your child is old enough to have a cell phone and communicate via text message. There are just so many bits of documentary evidence that can be helpful to establish your credibility of what you're saying is actually true to a judge. You can contact Next Chapter Family Law if you have additional questions or if you need help in showing that during litigation.